Hello, hello, hello. Happy Friday to everybody. Hopefully, you guys are all getting to watch from somewhere comfortable on this cold Friday, at least cold where I am. I know we've got some people in Florida watching this, maybe a little bit warmer for you guys. My name is Tony DiUlio. I'm an attorney who practices law all over the country doing property damage litigation, and I put on these lunch and learns to provide completely free information for people in our industry so that we can all strive to be better as a whole. Our industry is one that really focuses on helping consumers, helping property owners, homeowners, businesses, and we should all be striving to really increase our knowledge and our abilities in this area so that we can be doing the most good we can for those people who often are in some of the worst times of their lives when we get involved. If you don't know, we have an entire series going forward right now called Words Matter. I had a prior series called The Perfect Claim, along with miscellaneous videos in between. Please go back and check those out if you want a chance to learn even more about this industry. And as always, reach out to me with any questions you may have when things go south. I tell people this in every talk that I give, and the ones that really know me know that I mean this. I don't want you to have to send a case to me. The reason I do these courses is so that claims can be adjusted properly and hopefully never need to go to an attorney or come to me to fight after the fact. If it can be resolved beforehand, that is the best situation for the property owner. They don't have added things like attorney's fees. So hopefully these courses are, even if it increases your success rate by 5%, it's 5% of claims that are being handled properly and getting resolved without litigation, and that is a good thing. Of course, I can say that somewhat confidently because insurance companies do things wrong and they don't always catch their mistakes. Sometimes, I think it happens on purpose, but I'm there for those. If you ever need something, please feel free to reach out. I'm happy to discuss. As always with these talks, there is live commenting that I am happy to answer questions, address concerns, fix misinformation. Maybe I got something wrong. Nobody's perfect. So if you have any questions, please put them into the comments section. I will be reviewing them as always throughout this, and let me know. One of the big benefits of these live webinars are you get to ask those questions and get responses immediately right from me so that you don't have to be sitting around and waiting. So with all of that, let us jump into our series on part 4, Words Matter. This whole time we are going to be talking about exclusions. The exclusions portion of the policy is probably the most commonly reviewed section of a policy when it comes to loss adjustment, especially on all risk type policies, because this is really where the meat and potatoes is that limits coverage, things that need to be discussed and argued over. And to that end, we're actually going to be doing this in 2 parts. There's so much information and argument and discussion that needs to happen about these exclusions that I decided we really can't finish it in one session. So we're going to split it into 2. I would highly recommend anybody watching this time around to come next month for part 2 of this so that you can kind of get the full picture, see how it all plays together. I just can't fit it all within 1 hour. So we've got the second one coming up next month. These sessions go about an hour. I will do my best, as always, to fit it into that time. It usually has a tendency to go a little long, but I'll do my best. But one of the most important slides you guys can get is this one right here. This is my direct contact, my cell phone. It is with me at all times, but I might not always be able to respond right away. I might be doing something like this. I might be in court or in a deposition, or I might be with my family. I try really hard to get family time and do that type of stuff. So, if I don't respond right away, please don't be offended. And the other thing is know that you can follow up. I know it might seem annoying, but if you need to bug me, you've got permission. Text me, on a Monday, follow up on Tuesday. That's perfectly fine. You're never bothering. I promise it is okay with me to bug me as much as you need for a response, and I will get it back to you as soon as I can. This time around, I try to start with a quote. This one is, "He who has the power to give generally has the power to take away." And that's really what we're talking about when it comes to these exclusions under these insurance policies, because the majority of policies that you're going to be seeing are those all risk policies that say, hey, all direct physical loss is covered unless it's not. So they're giving all of the coverage broadly and then taking it away specifically. But how they do that within the policy is so important, because it's actually really limited as to what they're able to exclude, way more limited than insurance companies kind of pretend that it isn't. So I want to talk to you about why they are often wrong when they say things like these things are excluded under the terms of the policy, because it simply isn't true. Last time around, we talked about the actual items that are physically covered under policies, under both the structures, contents, um, other structures, and some loss of use. It's critical to have an understanding going into these claims what items are actually covered. So if you missed that, go back on YouTube or Facebook or even on our website at WDB Legal and take a look at those prior videos to get that information as well. This week, like I said, we're doing part one of exclusions, and we're going to be talking about kind of the exclusion framework, how these exclusions generally work within a policy. And then we're going to talk about the specific language of certain exclusions that are coming up all the time. I'm not going to talk about things like nuclear war because I just, hopefully, knock on wood, that one's not going to become an issue. But for the really common ones, we're going to go through some of the language, some specific cases that we've handled, showing how this policy language was attempted to be used by the carrier, why they were wrong, and how you can argue to get these things covered during the claims adjustment process. Uh, so let's take a look at kind of the framework of where we are. The section for exclusions almost universally, and when I say almost, I only do that because I'm a lawyer and I hate speaking in absolutes. I've never seen an exclusion section that doesn't start with some level of a preamble. Usually it is a concurrent causation provision saying that, these items aren't excluded regardless of cause of loss, sequence of loss, all these other things that we're going to look at. But that preamble language is so critical when you're reviewing these exclusions, and it should be the absolute first stop when you start this dive into the exclusion section, because it creates your framework of how this exclusion works with whatever claim I am making and moving forward. And it's not always the same. People have a tendency to believe that if one carrier has a wear and tear exclusion, that all of them act the same way and all of them have the same import when it comes to the preamble language and concurrent causation, but that's not true. They fall under different sections of these exclusions depending on carriers, and you really need to get your bearings as to which language is controlling for how this works within a loss. So hopefully you take a look at this language and start to realize after we go through all of this how and why this matters so much. So as I often do, I start with some examples of language from actual policies that we can look at to give us some framework. I can't stress enough, these aren't exhaustive of the examples. I've got a few in here from major carriers across the country, but I don't obviously have time to go and give you the example on every carrier. I don't have Hartford or Chubbs in here. I don't have AIG. All of these carriers that you're going to be seeing out there, it's not going to be identical. The purpose of this course is so that you understand how to review any policies language. It doesn't have to kind of walk you through the steps on every single one. So the Allstate language here that is important to start with talks about this preamble of concurrent causation and how losses are covered. And I want to point Allstate out because it's got two separate sections with two different preambles that actually have, when you really dive into the language, significant differences, and understanding that difference when you're adjusting the loss is going to be critical. So let's take a look at this very first one here. And it talks about under dwelling A for coverage and other structures. Great. So we know we're talking about the structures. We do not cover any loss which first consists of, is caused by, or would not have occurred but for one or more of the following excluded events, perils, or conditions. And such loss is excluded regardless of the cause or source of the excluded event, peril, or condition, any other causes contributing concurrently or in any sequence with the excluded event, peril, or condition. or whether the excluded event, peril, or condition involves isolated or widespread damage, arises from natural or man made sources, yada, yada. So, this initial preamble has some really critical language, and it talks about if these things happen, they are excluded regardless of what caused them to happen. They are excluded regardless of how widespread it is. As long as they are the but for cause of the loss, they are excluded. And it doesn't matter the sequence either. And the sequence is really important because the next section we're going to look at is not going to have that sequential language. And we're going to talk about why that matters so much. But here, it doesn't matter if they happened first or they happened last. Those items are not covered. I just taught a course down at the WIND conference in Florida. For those who don't know, WIND is a conference for both sides of the aisle, if you will. It's got insurance carrier representatives, IAs, defense attorneys, plaintiffs' attorneys, public adjusters, and we all get together in one spot to learn together, so that we're all playing with the same information. We're all understanding this industry and what is happening as a whole. And we did a course, and part of this issue came up. And a friend of mine, Matt Mulholland, who is actually on this right now as he's driving back to Florida himself, brought up a really good point because I always hated this language because it never made sense to me with the ensuing loss language. But Matt pointed out something really kind of eye-opening, was that it's not that it doesn't work with the ensuing loss. It's that these items, no matter what, aren't covered. It's not saying that the resulting new damage, some wear and tear causes a water leak, that the water leak's not covered, but the wear and tear is always excluded, regardless of where it falls within it. And that's why it can play nicely with the ensuing loss language. And I really liked that explanation. But this language really is that all encompassing, no matter when it happens, how it happens in the loss, those items themselves are not covered. The other section that Allstate moves to is this further down after it enumerates the stuff under A. It's got this B and C paragraph about predominant cause we're going to look at. But then it goes to D, and this has very similar language, coverage A and B. We do not cover losses consisting of or caused by one or more of the following. That's the same as it was before. Excluded events, perils, or conditions. Such loss is excluded regardless of whether it's widespread, man-made, blah, blah, blah. So let's look at these side by side. I know this is kind of small and cut off a bit. I know what I'm going to do here. I want to make myself a little bit smaller so we can fit a little bit more of this on here. And when you look at these side by side, they start off the same way and they end the same way. And that's important because what we had to figure out and really look at this is understand, well, what the heck is the difference, right? Both of them have language that says if the loss is consisting of or caused by. Both of them talk about whether it's man-made, widespread, isolated. What is the difference? And the difference comes down to the sequence of the loss. And it's so important to get this and understand this concept. So I'm going to hit on it now. I'm going to hit on it in the examples. And I want you to know I'm repeating it because of how important it is. Under section A, the sequence of the loss doesn't matter. It doesn't matter if the excluded event happens first, happens in the middle, or happens in the end. The excluded event isn't covered no matter what. Under section D, for these excluded events, it now matters the sequence of the events of what is actually the cause of the loss. This is reiterated because of a paragraph right above, which is paragraph C. When loss is not excluded under paragraph A or B, paragraph A we just looked at, and there are two or more causes of loss to the covered property, we do not cover the loss if the predominant cause of loss is or are excluded under paragraph D immediately below. So now we get this concept of predominant cause of loss, and we get this sequence now mattering more, right? Because let's say we've got a situation where there's a power outage and there's no exclusion for power outage. And a power outage causes a sump pump to overflow. If the sump pump exclusion is under section A, it's not covered, right? It's the sump pump is that backup or overflow from the sump pump isn't a covered loss. If the sump pump exclusion was falling under coverage D, and the predominant cause of the loss was the power outage, it wouldn't have happened but for the power outage. Now you've got coverage for those items. I hope that makes sense because it's really important, again, when arguing these under the policies and under the losses. Let's take a look at another carrier before we get into specific exclusions. This is Farmer's initial preamble. Again, I know it's too small to most likely to actually read. It's certainly too small on my screen. But the import of this is that it has similar language regarding this issue, and they title it a little bit differently. Section A is uninsured types of loss or damage. So that these things, similar to the Allstate policy, are not insured events, period. End of story, no matter when, where, or how they happen. If you go to the section B, these are excluded causes of loss or damage. So there's a little bit of a distinction when it comes to the farmer's policy, and you've got to make sure you make the analysis just like we did with the Allstate policy, that these excluded causes of loss or damage are separate and distinct from the uninsured types of loss or damage and how those play together. That is so important when you're making these arguments. Let's take it one more. We took a look at really long language from both Allstate and Farmers. Now we're taking a look at really straightforward language from Nationwide. Nationwide just has one sentence. We do not cover loss to any property resulting directly or indirectly from any of the following. Such a loss is excluded even if another part of the event contributed concurrently or in any sequence to cause this loss. And then it's got the next section. We do not cover loss to any property resulting directly or indirectly from the following if another excluded peril contributes to the loss. So again, it is separating two different categories of excluded damage under the policy and doing it in a different way to recognize, okay, these ones aren't covered no matter what happens, and these other ones aren't covered only if there is some other excluded basis that goes along with them. So let's take a look at some of these exclusions. You're going to see as we review these that the exclusions are really similar in these first sections of the policy, but there are still nuanced differences. And they're nuanced on really important issues, things that are some of the most common exclusions that come up in the day-to-day, fall under different sections. And we need to make sure that as we are doing the read-throughs of these policies, because you should be reading the full policy, right? RTFP for when you're going through this, so that you've got an understanding as to where everything falls. Allstate, under their Section A, has their relatively standard list of items that fall under that first section of excluded perils: flood, surface water, waves. Water which backs up through sewers or drains, water that overflows from a sump, water below the surface of the ground, earth movement, actions taken by government, nuclear hazard, war, soil conditions, vapors, fumes, smoke, soot, lack of utility, the freezing pipes, inability to use, seizure, manufacturing of drugs, and weather conditions. This list falls under that very first section, Section A, of excluded regardless of the sequence, right? First, middle, or end. These things are not covered no matter what happens, right? So if the flood water only gets in because of a windstorm, doesn't matter. It's still flood water. It's regardless of where it falls, not covered. If we take a look at the next one, for Nationwide, you're going to see really similar stuff, right? Earth movement again. It moved from 5 up to number 1. But then we get flood, surface water, waves again. We get water which backs up through sewers or drains, water that overflows from a sump, water below the surface of the ground. But now Nationwide added in a new one that wasn't in Allstate: neglect, war, nuclear hazard, increased hazards, intentional acts, another one that is new, actions taken by government, collapse, another one that's new, pollutants, loss assessment, government acts, and biological deterioration, aka rot and mold. So now under Nationwide, we've got this under the first section of exclusions that is different and separate apart from the Allstate one. And I'm pointing this out because you need to, I'm going to sound like a broken record. You need to know when it falls under the first section and when it falls under the second so that you're arguing them properly. And we're going to talk about how to do that with some actual real life examples of these moving forward. So recognize the distinction between these as you're moving forward with your loss adjustment. One more, my personal favorite, State Farm. State Farm has claps listed just like Nationwide. Freezing of plumbing, freezing of the outdoor stuff. I generalize that, but the pools, ponds, things like that. Theft while under construction, theft while vacant. Those two are new compared to the other carriers. They don't have them. Seepage of water over a period of time. Don't even get me started on how ambiguous that phrase is. Wear and tear. For the first time, wear and tear is showing up under the first section of coverages and exclusions under the policy. Corrosion, rot, pollution, settlement, animals, and tree roots. So these sections, again, hopefully you are understanding and appreciating that while they are incredibly similar, and while they might have, every carrier has a wear and tear exclusion, where it falls could be different and change your arguments. So let's take a look at some of the actual language from these policies and things that you should be doing when you are arguing them to ultimately get the carrier to the right position of coverage. So first and foremost, Allstate's example for their flood and water exclusions under the policy. As we all know, there's a lot of water that is covered under a policy, and there's a lot of water that isn't covered under a policy when it causes damage. And the most quintessential, obvious example is always a flood, right? Floods under homeowner policies are not covered unless you've got a specific flood coverage with a carrier that provides that generally through FEMA, although there are some third parties that are providing flood coverage now. So flood is a perfect example because the concept is this is water off of your premises that is getting onto your premises, causing damage on some widespread scale issue. And if you take a look at every type of water when you go through these sections, number one, flood, which is surface water, waves, tidal water, overflows of bodies of water, spray from any of these. All of those are off premises sources of water coming onto my premises. Number two, water or any other substance that backs up through sewers or drains. Now, this one is really important because the history of this provision is actually critical to the analysis of what the heck they actually mean by this. Sewers and drains, when this first came in, was actually talking about the sewers and drains in the streets, right? Your sewer drain would, those grates that you would see where it, had the little boat for Billy, yeah, Billy Boy. No, that was the brother. I forget the name of the son. The little brother. Those were sewers and drains. That's what was always thought about when talking about backup of sewers and drains. So that is off premises water getting into my property. And that's what this provision is really talking about. This provision is not, I want to stress, is not talking about water from my own plumbing system. So that if I, in essence, have a blockage in my personal drain line, and that blockage causes my toilet to have water escape, that is not a backup of water. The water never reverses flow. What I tell people all the time is think of a bus. When a bus goes into reverse, you start hearing that beeping noise, right? Beep, beep, beep. That's what the water would need to do to be considered a backup. You actually have to have a reverse flow, reverse pressure onto the property. Now, what unfortunately happened was the carriers started using this language to mean drains within a person's own property or sewer lines within a person's own property. And they started adding language that was beyond just backup. They started saying backup or overflow. And even that we were able to kind of work our way around and say, well, look, this wasn't an overflow. It was just the discharge of water, no different than when a line breaks and water escapes from it. But then they got even further and they said, well, water that backs up, overflows, or is otherwise discharged. And they really are trying to broaden this because they just didn't like the idea of providing coverage for sewage that was entering a person's property. But what they could never really get around is if it is my sewage, if it's my stuff that is getting into my property, most of these policies should be covering it. There is a great question from Franklin Horowitz, and this one comes up all the time with some of the recent breaks that have happened. And the question from Franklin was, how about a water main break? Water main breaks, depending on what state you're in, can often be covered under these policies, regardless of these exclusions. And what the courts have come down in, there's great case law in New Jersey, mediocre case law in Pennsylvania. But in New Jersey, the courts came back and said, look, the source of the water is a man made source. That this is not, natural sources of water that are coming back into the property. And if you look through these and look through the four sources in the Allstate policy, they all are truly relating to natural water that is intended to come in, and that's important because when they talk about the sewers and drains in the street, again, we're talking about that storm water that is overflowing. What they intended to exclude was if there's a really bad storm and the sewers and drains couldn't handle the amount of water that was associated with that, and it ultimately gets into your property, you're not covered for that. It doesn't have to be a flood. It could just literally be a sewer drain that can't handle it. That's not covered. So they came in and said, well, look, the water main break is no different than a person's own supply line breaking in their home. And just because the path of the water went over the surface of the ground, the source of the water is not groundwater, ground or surface water. And they really focused in on the source as being the cause of the loss, not the path of the water. So when you're making the arguments for these claims, the argument is always the source of the water is a covered source, not the path of the water. Because if you get into that path of the water argument, it becomes infinite, right? Where's the path of water that ultimately gets in my house? Well, it rained at some point and that collected in a reservoir somewhere, and that it got into my house through plumbing systems. So, well, isn't that, ultimately surface or floodwater, some ridiculous arguments that would always lead to an excluded loss. And the courts agreed with those arguments. So Matt Mulholland followed up, source language exists in Florida. It's actually existing in other places as well. And what carriers have done, again, trying to erode coverage, which is happening all over the country. They are just taking coverage away and putting it under the guise of clarifications, which is totally bullshit. The policies are starting to say, regardless of the source, and they've got language that has now gone and said, regardless if it's natural or man-made, when it comes to the water damage portion of the policy. So they took away the argument of natural versus man-made, and they took away the argument of the source. And they're smart. They're doing it because they realized we were winning these cases when that language didn't exist in the policy. But not everybody is doing that. Not everybody has that language in there. And for the ones who don't, you still have viable arguments and fights to be made as to why these items are in fact coverage. All right. So if you continue to take a look at these substances that overflow from a sump pump, sump well, or other system designed for the removal of subsurface water, which is drained from a foundation area of the structure. Again, that gives us really good evidence that we're talking about off-premises water. All of these are talking about off-premises water, and that's so important for understanding this exclusion, because when you've got on-premises water, these do not apply. There's a concept in the law that is a Latin phrase, adjudice jacorum, I think, or something like that. I honestly can't remember the Latin for it. But the concept is that words are defined by the other words around it. So we look at the context of everything that we were reading within the policy to know exactly why this is, in fact, covered when it's on-premises water. The last one is any water or other substance on or below the surface of the ground. This includes water or any other substance which exerts pressure on or flows, seeps, or leaks through any part of the residence premises. I want you to remember that one because we're going to look at an example, excuse me, in a little bit that talks about that exclusion in practice and what is actually happening, along with some other exclusions as well. All right, so keep moving forward here, taking a look at the next section of earth movement. I brought this one up because, again, one of my examples is going to be kind of lumping this all together into one good example. But the earth movement talks about the earth movement being the cause of the damage to the property. And I want you to really understand that, because unless the earth movement was the cause of the damage, not the result, but the cause of the damage, the exclusion does not apply. For example, vibration cases, explosions. The vibration cases come up all the time when there's new construction happening on properties, and often a carrier will attempt to say that, oh, this is settlement or this is earth movement, and that these aren't otherwise covered. But that's not what caused the loss. The cause of the loss was a vibration. It was the construction next door. It was explosions or blasting. All of those things are covered, right? It's construction equipment. Those vehicles causing damage covered. Vibrations are not excluded. And vibrations aren't the earth movement themselves. Vibrations are the waves, in essence, the sound waves coming off of these items, not excluded. All of these things being the actual cause, not the result, make these covered causes of loss. So when you've got an earth movement case, they're really talking about things like sinkholes, even earthquakes. That type of earth movement is what they are excluding. It doesn't simply mean, oh, because the earth moved also, it's not covered. Can't stress that one enough. It's also important to understand what do they really mean by the earth movement when that's not the thing that is moving. I had a case in Philadelphia, an old 100-year-old building was built on top of the demolition rubble of the building that was there before it. They just never excavated. They literally just built on top of it and put the foundation, used that almost as like the base of the foundation that they built on the property. Well, over the years, that rubble compressed and created a void underneath, and ultimately the building collapsed down, causing damage, significant damage to the property. And the carrier came back and said, well, that's earth movement. No, it isn't, right? That was the debris compacting underneath. That's not the earth. So there was coverage for that loss as a result of the fact that they were trying to rely on this earth movement when it wasn't, in fact, the earth that was moving. All right. Keep moving through because these always, I'm only halfway through these slides and I'm already beyond my halfway point. So here is the example. It wasn't actually an Allstate case, but it has the same fact pattern that works really well for it. We have a relatively typical situation. This is a basement wall that fell in, and this was the result of the loss. The question becomes, was this covered under the insurance policy? As you can imagine, the carrier came back and threw out all of these really typical exclusions, right? Number one, hydrostatic pressure. They said, well, look, this is groundwater that's exerting pressure onto the wall. That's what caused the loss, and therefore it isn't covered. In addition, it is earth movement, right? Earth movement caused this wall to collapse, so therefore it is not covered under the policy. So I want you to start thinking to yourself, well, how would you argue that this is in fact a covered loss? If anyone has a thought as we're talking about it, you can throw it into the chat. I'll be curious to see what you come up with as I'm rambling, to give time to anyone who wants to respond. But the answer is that this is, in fact, a covered cause of loss, because all of those things, hydrostatic pressure, earth movement, aren't the actual cause of what happened here. Now, I'll tell you one of the facts that is probably important for this. This home was about 75 years old when this happened, down in the basement, and it was an area of Philadelphia that this wall had collapsed in. And what we came back and said was, this didn't happen because of hydrostatic pressure or because of earth movement. First and foremost, earth movement was the result, right? We have this collapse that occurs to the wall. The earth was then allowed to move after the fact. Had nothing to do with it. We're not claiming earth movement. We're claiming the wall. So we take earth movement out of the equation entirely. And then the next question was hydrostatic pressure, whether or not that was, in fact, the but-for cause of damage to this wall. And the courts came back and said, no, there's not enough evidence to show that that is the but-for cause, because what actually happens with a 75-year-old wall, you've got hydrostatic pressure the entire time, right? There is always hydrostatic pressure pushing on this wall. Sometimes it gets worse, sometimes it gets better, depending on stormwater, groundwater, all that kind of fun stuff. But the hydrostatic pressure is always there. So what changed? And the answer is, well, what changed was that the wall got older, that the wall started to deteriorate, that it got some wear and tear, and that as a result of that deterioration that no one knew about, no one could see, this wall collapsed. Now, if you've watched my prior videos, we talked all about the collapse additional coverage, and that under most policies, that additional coverage for collapse includes hidden decay. So that because this wasn't an Allstate file, we put forward that this was a hidden decay issue with the wall, and the court ultimately came back and agreed with us. So we've got these covered causes of loss that are nuanced based off of those provisions of the policy, where we could argue we are not claiming anything as a result of hydrostatic pressure or earth movement. We are making the entire claim under collapse. And that presentation of the claim made all the difference in ultimately getting this to be a covered cause of loss as the result of that hidden decay and wear and tear. There's a few other exclusions I want to talk about when you're arguing these, and I've done entire courses on this specific provision when it comes to ordinance and law and code enforcement. This exclusion under the Allstate policy, relatively similar to other carriers, it says that actions taken by civil, governmental, or military authorities to enforce any building codes, ordinances, or laws regulating or requiring the construction, reconstruction, maintenance, replacement, repair, placement, or demolition of any building structure, other structures, or land on the residence premises. I want to explain to you how this came about. If codes changed, which they inevitably do over time, you could not go to your insurance company and say, hey, knob and tube wiring is no longer permitted by code. I've got to replace an old line because it's now fried in my house, and I've got to replace all of my electrical. Come on, Allstate, pay me for that repair. No, you're not covered for that. You are making a repair because of uncovered damages, right? Wear and tear to electrical, whatever you want to call it. And now you've got to make make more work purely as a result of the code. So sorry, you're not covered for that. However, that is not the same as repairability issues when it comes to a covered loss. If you cannot make a repair as to a covered loss without taking into consideration codes, that isn't because of code enforcement. It is the repairability issue. Perfect example. You have siding damage on the side of a property. The siding must be placed as a result of code on the over a weather-resistant barrier free from holes. Okay, that's the house wrap. All on the same page. When I pull that siding off of the property, I have house wrap that has holes in it. As a repairability issue, no contractor is legally allowed to make that repair without putting on new house wrap that is free from holes. Okay, well, now I get my house wrap covered as a result of the claim. What does that mean for my loss? Well, house wrap has to overlap by 6 inches on any vertical surface. So it has to wrap the corner. You see where I'm going with this. You have to pay if you're paying for the left side, and that left side connects to the front. You've got to pay for the front side as well. And that is really frustrating for carriers because they come in and say, wait a second, you've only got damage on one side of your house. You're asking for the whole house. That's code compliance. We're not doing it because of the code. We're not paying for it because it's code compliance. No, that's not what I am claiming. This cannot be repaired. Nobody will physically do the work without following this rule. So I have to have this done when I make the repair. And when they say, no, it's because of code, you say, okay, tell me this, Allstate. I've got asbestos tile in my bathroom, right? There's a covered loss. That asbestos tile has to come out. Are you telling me I have to go back and put asbestos tile in because that's what was there before and that's what gets paid under the policy? No, of course not, right? No one is putting asbestos tile in, and it's because of the regulations against asbestos use in tiling now, but you're still paying for that loss. It's no different when you're paying with when you're paying for the house wrap as well. David, I can get you the International Building Code provision, and all you need to do, just so you guys are all aware of how to do this, most states in the U.S. have adopted the International Building Code, and they adopt different versions of it. The IRC is the residential code. There's a commercial code as well, and those have the provisions, generally speaking, for this house wrap. What you'll need to do is show during the claim the local code that says we've adopted the international code, and then show them the international code for the repairability issue, and we can get that out. I'm going to put, if you didn't take it down, I'm going to put my email address right in the chat so that you can email me particularly you, David, if anybody wants a copy of the building code, I'm happy to send it over to you guys. Excuse me. Um, so that you can have a follow-up side note to send it to you for anybody that wants it. Again, there's a whole course I did. One of my videos is on this, the code enforcement. So if you want a much more in-depth um, review of that, please go take a look. So a few others that I want to hit on before we run out of time. Allstate did not have the wear and tear provision contained within this first section of exclusion. And we're going to talk about the second set of exclusions in the next webinar when we finish this excluded portions. But Nationwide did. Nationwide has the wear and tear provision as part of the as part of this first round of exclusions. So I wanted to talk to you guys about this, at least in some context, because it is, I think, the most commonly quoted exclusion in almost any insurance policy. I'd be curious if you guys believe that there's something that is quoted more often, but I think this is the most commonly quoted provision within the policies. And it is overused by carriers because it is such a limited aspect of what isn't covered as part of a claim. And again, the critical aspect here is that the wear and tear portions aren't covered. Fine. That doesn't mean the rest of it isn't. So, for example, you've got a stucco claim. Stucco causes water to infiltrate the home, and it's been infiltrating the home for 3 years because it didn't have the proper weave screed and it was improper construction. So there's rot, there's wear and tear, there's all this stuff going on behind the wall that isn't covered. But one day a storm comes by that's bad enough that water gets through all of it and damages the interior of my property. Most carriers recognize that as a covered loss. It's ensuing water damage that isn't otherwise excluded within my policy, and then they come back and they say, all the damage to the exterior is from wear and tear, to the caulking or improper construction, or mold, rot, and decay, all these other things. And we say, fine, I understand that those aspects of the claim are not covered, but you and I are in agreement that any water that got through this storm, any water that got through during this one, is covered because you paid for the interior, right? Right. Well, that water to get inside had to pass through the sheathing. It had to pass through the insulation. And when it does that, you can now pull in the coverage for any of that water damage to the sheathing from this storm. Because when the sheathing, and they use this all the time, oh, well, the sheathing can dry out. Not when it's encapsulated inside the wall. Sheathing can dry out. When a home is being built and it's sitting out in the elements and it's open to the sun and the air and all that stuff, it gets wet and it can dry out. Absolutely. But once it gets covered and it gets encapsulated, it doesn't dry out. It starts to break that the glue and the bonding agents down inside that sheathing, and it's got physical damage as a result of the water. The sheathing has to come off to make the replacement. That means the stucco has to come off. All of it is covered as a result of the water damage that got into that property. It doesn't matter that there are certain aspects of it that aren't. It doesn't matter that there's rot. It doesn't matter there was improper construction. It's covered as part of the water damage claim, and it's so important to recognize that. And it's really simple, right? It's equivalent to these walls. If there was a nick on the wall behind me, right? Let's say there's a ding in that wall. This is an example I use all the time in court, and it's very effective. That ding isn't covered. It's wear and tear. It's negligent. Whatever I don't care what you want to call it. It's not covered. If that wall burns to the ground, the wall's covered, right? It's just like the roof. If my roof is 40 years old, beat to all hell, if my house burns down, it's still a covered roof. It doesn't matter that there's wear and tear. It doesn't matter that these things exist. And then you get a claim that is similar to what is up there. For example, a windstorm to a 40-year-old roof. Carrier comes back and says, well, the wind only damaged it because it's worn and torn. So sorry, you're not covered. No, that's not how it works. The wind aspect is covered. The wear and tear isn't. That's it. You've got a covered cause of loss. Jason, you had the question, in your example for stucco, are you bringing in the 6-inch overlap to re-stucco the house? The 6-inch overlap, the code is for siding in particular. Stucco is installed a little differently on the home, as you probably are aware. But what's interesting about stucco is that truly you can't just patch stucco and get back the same product you had before. The example we use is Play-Doh. You take a ball of Play-Doh and you roll it up in a ball and you let it dry. and then you crack that ball so that some of the Play-Doh falls off, and you take new Play-Doh and stick it to that ball. Sure, it'll stick and it'll be on there, but it isn't attached the same way as the original stucco. So most stucco experts will come in and say, look, yeah, you can do a temporary patch, but it's not what they had before. It's much more susceptible to leaking in the future, to failure. It becomes a maintenance problem down the road, and they didn't have a maintenance problem with the stucco previously. So we've got to replace the stucco on the property. All right, so that's the wear and tear. Again, you've got to make sure that when you are presenting this, you're presenting that I'm not claiming the wear and tear. There is no damage, not one penny of my loss that is the result of wear and tear. It is not the result of any of these excluded things. I need you to understand I am claiming all of my damages as a result of the water that came in after the fact, the ensuing water damage under the policy, and that is covered, that everyone recognizes is covered, and that my damages are because of that, nothing more. Wear and tear or no wear and tear, my damages are identical because it's for the covered damage only. All right, so another important one is claps. We talked about this briefly before, so I'm not going to harp on it for too long. The claps coverage has very specific provisions as to when it is added back in, right? So Nationwide has claps coverage under their first section, but it says, claps is excluded except as otherwise available in the additional coverages. So you go to your additional coverages, and you need to take a look at this particular section of the causes of the collapse, right? So that if it's one of the named perils that causes the collapse, you're covered. If it's hidden decay of supporting or weight-bearing building structure members, it's covered, right? Like that wall, that foundation wall is a weight-bearing structure as part of the house. That wore and tore, it is covered as a collapse. Also, hidden or insect damage, the weight of contents, equipment, animals, or people. Deck collapses can be a really common one for the weight of people. Rain, ice, sleet, or snow, which collects on the roof. So if you get a really bad windstorm and you've got a flat roof snowstorm, and you have a flat roof that collapses down as a result, you've got coverage for that. Make sure you read these because they are different for different carriers. I want to point out the Allstate policy does not have the hidden decay provision. This was a big mind blower for me when I first started, and I was like, "Oh, this was an Allstate. I had an Allstate claim that had a collapse, and I originally just presumed that it was going to be hidden decay. Of course, covered. Well, Allstate didn't have that provision, so we needed to make sure that we did this full review to get to that right result as to the actual cause of damage to the property. So you need to be reading these policies. Do not assume they are the same as other policies that you have, in fact, reviewed. All right, another really important one that comes up all the time for exclusions. I used State Farm as example, but this is the freezing provision. For those who don't know, generally speaking, freezing provisions under policies say something like you're not covered for freezing unless you've taken reasonable steps to maintain heat at the property. Period, end of story. Or you've winterized your pipes. And winterizing the pipes generally means you're draining your lines of any water that is within them and shutting the water off to the property. You want to go over and above, you use some antifreeze and put it in there as well. But State Farm recently changed their policy over the past couple of years, and a lot of people didn't recognize this. So they started putting claims in for freezing without realizing that now State Farm is requiring 55 degrees Fahrenheit must be maintained at the property. So unless you've used reasonable care, and that must be maintained, you use reasonable care to maintain 55 degrees. So now they've actually put a provision because we were winning cases where the people would set the thermostat to 50 degrees, 45 degrees. It's above freezing. They had a reasonable belief to think that that would keep the pipes from freezing. And that was good enough, right? That was reasonable for people to do. Well, State Farm has now thrown in an actual temperature. So make sure you know when you're putting forward these claims with State Farm or other carriers that have a temperature that you've got the evidence to support that. And remember, it's not absolute. It doesn't have to be that you actually maintained it. You just have to take reasonable steps. A perfect example that gets fought all the time. You have a property that is a rental property that happens to be vacant because you're in between tenants. You check on the property once a week. Everything seems fine. You've got the temperature set to 60 degrees. Well, the heater breaks, and it breaks the day after you checked it. And now for a week, there's no heat on at the property at all. The pipes freeze. And the carrier comes back and says, I'm so sorry, you did not take reasonable steps to maintain heat because the heater broke. There was no heat at the property. But that's not the measure. The measure isn't absolute. It's exactly why we have this coverage. All you need to show is we were trying, right? We were taking reasonable steps. And checking on your property once a week is obviously reasonable. Probably reasonable to do it less. But you've got the heat on, you've got inspections going at the property. That's reasonable to maintain heat. It doesn't have to be absolute. Because obviously, if it was absolute, you wouldn't have the frozen pipe. So that is why that coverage exists, and that is exactly what you need to be arguing when these claims are put forward. Um, this next one is one that has been coming up more and more, and it's all about pollution under the policy. And it's pollution in most policies has not been defined adequately. It is incredibly broad, and some policies are better than others at doing it, but most carriers try to use this really broad sense of what pollution really means. So, what really constitutes a pollutant? Right, there are things that we kind of know, right? We picture, the smog coming off of a factory into the air, the water that gets contaminated from somewhere and causes cancer to a whole town. Those things are pollutants. We get it. But what about more localized issues? So we go to the dictionary and we say, okay, well, what's a pollutant? Webster's gives us the really helpful definition. It's something that pollutes. Thanks. Really, Webster's top notch defining there. But let's take it to the next step further. What is pollutes? Well, pollutes comes back with a little bit more help, and it says the first one, make ceremonially or morally impure, doesn't apply to us, but section 2 could apply. It makes physically impure or unclean. Okay, well, doesn't every loss we have kind of make things unclean? Water staining on the walls, soot from a fire. I mean, all of it is unclean or impure, right? It's not the way it was built. So that doesn't really help us either. So the courts have gone further and they start looking to other things that have defined pollutants like statutes and codes locally, but it creates this ambiguity within the policy. So we have fights. I have fought over every one of these as a fight for whether or not it constitutes a pollutant. You spill bleach on your carpet. Just unfortunate accident happens and it stains your carpet. Is that a pollutant? Because doesn't it makes it unclean? Well, maybe it actually cleans it even more, but impure. It's damaged the property. If there was a bleach spill in the ocean, it would be a huge problem, or in a lake somewhere. That does that constitute a pollutant? How about blood? We've had losses. Unfortunate things like suicides, bodily fluids. Does that constitute a pollutant? Because I've got literally a case going right now where the carrier said that constitutes a contaminant and a pollutant, and therefore it is not covered. Gasoline stored in a garage or in a basement. Home heating oil, right? Not heating oil from a truck, just my own home heating oil leaks onto my basement. Is that a pollutant? Lead paint, asbestos, which is that bottom right one. You might not be able to tell. Are these things pollutants under the policy? And generally speaking, if the policy doesn't give a good definition of a pollutant, there are arguments to be made that all of these things are, in fact, not pollutants as intended under the policy, because they aren't the things that somebody would think, oh, this is pollution getting into my home. That is what the exclusion ultimately relates to and matters for. So before we get into the questions that came before, I've gotten through this at some good pace. Here are the big takeaways that I hope everybody understands. First, I say it often, read the effing policy, right? This is a common theme in every talk because people just don't do it enough. It's so frustrating when people come to me that these policies still are not being reviewed, that you're not getting copies of them. I know how difficult that can be, but there are avenues that are not being explored to get them and being reviewed. So read the policy. Always present your loss for just the covered loss, right? And when you're presenting it, Acknowledge the not covered portions. It is so much more valuable. The number one thing, if you could take away anything from this, I want you, when you present your claim and send it into the carrier, I want you to have in your letter, hey, I recognize that there is wear and tear. I recognize that there might be mold or rot or other issues. I recognize all those. And I want to tell you right now, I'm not making a claim for those things. It's not part of my loss. My damages, not one of them is because of rot, mold, decay, wear and tear, other excluded issue. Those aren't my claim. My claim is because of why this, this covered loss. That is it. And if you acknowledge that from the start, it's much harder for them to come back and say, well, we're not paying for your loss because of these things. I'm not claiming that. I don't want you to think I'm claiming that. So head it off ahead of time. People have hesitations doing that because they come in and they say, well, aren't I just telling them why to deny the claim? No, you're specifically telling them you're not claiming it, so they shouldn't deny it for those reasons. So as always with these webinars, we ask people for questions that come in, and I tell everyone I will address all of your questions, regardless of if it's on topic or not, because I want to make sure that all of you are getting heard and that it's an opportunity for you to come talk to me. If I missed one of your comments in the side, please let me know. I've been trying to look over and read as they are coming in. But if I did miss a question, put it in now so that um, I can address it through this question portion. But there are a few that came in ahead of time, and a number of them were actually on point, so they're important for this. Does alleged wear and tear to an oil-fired boiler unit warrant exclusion to a soot puffback claim? So I really love this question because it can encompass all of the concepts that we just talked about in reviewing the policy. And that's the first thing I'm going to tell you is you've got to review the policy to find out where these exclusions are contained within the policy and how they work with both concurrent causation and ensuing loss. But my gut answer is the soot should probably still be covered. And the reason being is it's no different than your broken plumbing line, right? Wear and tear over time will deteriorate any plumbing line in a property. It's just a matter of time. Whether that time is 20 years or 200 years, obviously is different, but it will at some point break. The pipe itself is not covered. Here, the oil-fired boiler, probably not covered. But the resulting damage, the resulting soot, the puffback, it could be either under explosion coverage if you need a named peril, or otherwise not excluded within the policy, so that resulting damage is in fact covered under the policy. If you've got other coverages you're going to want to look for things like mechanical breakdown, you want to take a look to see if there's a way to get the boiler covered as well. But at least the soot should be covered. That was a tough one. Soot should be covered. How does the backup exclusion work if caused by an internal clog or a drain pipe failure / break in New Jersey? So this is what we were talking about before. I kept it in here to reiterate, though, that if you've got a clog on premises and your policy says that backups are not covered or overflows are not covered, that is not a basis for exclusion under the policy. You do get into what I'll call gray water when you're talking about a policy that says or otherwise discharged from a sewer or drain. The truth is, I have stood by the position, and we're about 50-50 on this argument with the courts, that when they're talking about sewers or drains, they aren't talking about my on-premises drains and my on-premise sewer line. Here's the argument that I put forward. My partner always laughs at me for this one, but I think it actually makes sense. A school is a school. A school bus is not a school. Just because the word school is in it, a school bus, doesn't make it a school. I think everyone agrees with that premise as in general. I've got a sewer line from my house, but that isn't the sewer. Just because the word sewer is in there does not make it a sewer. It is just the sewer line. It's what takes things to it. It's my plumbing system. That's what it actually is. And when I've got a breakage in it, or a clog in it that causes water to escape, it is on-premises water and should in fact be covered under the policy. All right. Can you provide clarification of the exclusion caused by an act or failure to act of an individual, etc.? So I took a snippet from one of the policies: the failure by any insured person to take all reasonable steps to save and preserve property when the property is endangered by a cause of loss we cover. This is the provision that says, all right, you've got to try to protect your property from further damage. Um, Most of the policies have some level of reasonableness involved in here. And where this really comes in is when people don't act. And the carrier comes back and says, well, look, you did not protect your property from further damage. You let it get worse, and now we're not covering any of the claim. The important aspect here is you've got to try to differentiate what happened as a result of the failure to act versus what the original damage was. If you can make that distinction, you can usually get coverage under most policies. The other thing that comes up often is when someone does act and it causes the damage to no longer be inspectable. Easy example: a flat roof. You've got a flat roof that has some wind damage, some lifted seams that ultimately needs to be patched to make sure that more water doesn't get in. So you have a roofer come out, they put some patches on just to cover up the openings so that no water gets in. Carrier comes out, says, oh, so sorry, you covered the damage. You didn't give us a reasonable opportunity to inspect when we requested, and therefore you're not covered. Totally bullshit denial. It should be covered all day because you've got this requirement to protect the property. And when you do it, it specifically states under most policies that all you have to do is document your expenses and provide those when requested. So you've got a ton of arguments to get around that as well. The Nationwide did an unknown inspection of their client's roof. They found hail damage and non-renewed their policy. Their hail report shows hail in the area over 1 year ago, which is just outside the statute. Any recourse for the homeowner? Short answer is unfortunately no. If the hail damage was unknown, if it's got a provision within the policy that has a 1 year reporting period for hail damage, I can't really think of a way around that. It's unfortunate. If someone's got a suggestion on it, I'm all for hearing it. But if you're past that statute time, that hail reporting period within the policy, there's just not much you're going to be able to do on that one. Two more here, I think. Can a public adjuster also be the contractor on the same project in New York? If yes, does that also include remediation? Here's what I tell every time someone asks me a question about what a public adjuster is allowed to do when it comes to construction. I'm not the expert on that. This woman is. For those who don't know, Holly Soffer does work all across the country on compliance for public adjusters and contractors. She will know this immediately off the top of her head. I would have to research it. So give Holly a call. Honestly, her name, if you go to any public adjusting board and ask a question about contracts or compliance, pretty much everybody recommends Holly. I mean, she's absolutely unbelievable. So please give her a call. Her contact information is right there if you need it, and don't write it down fast enough or take a screenshot, which you can do right now. Feel free to email me or text me. I'll be happy to get it for you. Last question, unrelated to this course. What if the appraisal goes south, but the lawsuit has been filed previously? I got to be honest with you, I didn't really understand this question. What I can tell you is make sure you get your writs and your complaints filed before your suit limitation comes up, even if there is an appraisal that is pending. There are attorneys out there, some very vocal online, who have taken an absurd position in my eyes of, if you're an appraisal and you get an appraisal award that comes in after the suit limitation, they won't pay it. Absolutely insane, but they really want to fight those fights. So let's just avoid the fight and get the complaint filed or the writ filed ahead of time. As always, thank you so much. I really appreciate you guys joining me for these. Hopefully you keep finding them valuable. If there are topics you would like to hear me talk about, please let me know. I'm happy to add stuff in. I did courses on appraisal. I did courses on code compliance and code upgrade. I did courses on, there's so much stuff out there. So go back and look, but I always want more content. So please feel free to reach out anytime with anything you guys need. I am here for you to be of help. And if I can help in a way that doesn't get it into litigation, that is the ideal situation. So please do not hesitate to reach out and to bug me. That's what I'm here for. Thank you guys so much. Have a great weekend, and I'll see you next time.